Hello again, everyone. Welcome to Washington Gun Law TV. I'm Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's premier indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. And we're going to talk about a really important case. And I say it's really important because it's actually opening up another level of analysis that I don't think's been conducted before. I think it's really important. And it relates to this. Unserialized firearms, 3D printed firearms, homemade firearms, personally made firearms, ghost guns, whatever you want to call them. This is a whole new area of litigation that we're really just beginning to scratch the surface. There is a case out of Delaware that I think could turn out to be perhaps the most important case when it comes to litigating this entire issue. It has a lot to do with what Delaware did to its residents through the passing of different laws. It also has to do with the way that I think the plaintiffs have very intelligently here gone about and tried to apply the common use test to unserialized firearms. So today, let's slow it all down, let's geek out a little bit, and let's talk about how this will be the most important case for homemade firearms. Okay, so the case we are talking about today is the case of Rigby v. Jennings. It is brought to us by our good friends at the Firearms Policy Coalition. It is filed in the United States District Court for the District of Delaware. Kudos to the Firearms Policy Coalition. I think they've done a fantastic job. We're going to geek out on this brief in just a moment, and we'll also put a little link down below, so if you want to show FPC some love, you will be able to do so. Now, as I mentioned in the opening, one of the reasons that I think that this Delaware law is the perfect law to actually take this issue up on is not only did they ban the assembly and manufacture and sale of unserialized lower receivers, things like that moving forward, they also made the possession of these firearms immediately unlawful, and there was no grandfathering provision. So essentially, you had thousands of Delaware residents who overnight became criminals for simply possessing an item which was at one point completely lawful to possess. As the plaintiffs have very wisely pointed out here, House Bill 125 bans A, the possession, transportation, shipping, transfer, or sale of non-firearm objects, NFOs, i.e. various items and materials that, while not themselves firearms, may be used in the manufacture of a firearm. B, the possession of self-manufactured firearms, self-made firearms that do not bear a federally licensed firearm manufacturer's serial number, as well as, prospectively, the use of three-dimensional printers to manufacture such firearms, and C, the distribution by any means of any instructions in the form of computer files or code that may be used to program a 3D printer to manufacture or produce a firearm receiver, or major component of a firearm. So as you can see, what Delaware did here is they completely stopped everything. So that means that if you possess a firearm that you manufacture without a serial number, you're now a criminal. If you assemble a firearm moving forward, you're a criminal. If you sell a lower receiver without a serial number, you're a criminal. If you buy one, you're a criminal. If you're printing components with a 3D printer, you're a criminal. It completely across the board outlawed all of this activity. So what the plaintiffs are asking for here is two things. Number one, a summary judgment. Now, for those of you who geek out on the channel, you know that a summary judgment is basically, hey, judge, we don't think that there's any real material issue or dispute about the facts. We really don't think there's any dispute about what the law says. And when you do all of that, you realize that, hey, we're entitled to a judgment, so just give us the judgment now. Let's not even do a trial. The other thing that they're asking for is a permanent injunction, not a temporary injunction, but a permanent injunction. Now, because it bans items moving forward and items currently in possession, and then it also bans the dissemination of information, because remember, any dissemination of 3D printing blueprints or schematics or anything like that is also banned under this new Delaware law. We're dealing with the Second Amendment, we're dealing with the Fifth and 14th Amendment with unconstitutional takings, and we're also dealing with the First Amendment restriction of free speech in the dissemination of these blueprints. Now, just to cut to the chase, we know that today we analyze gun control legislation by asking ourselves, does the text of the Second Amendment cover the activity in question here? Well, yes, this is the possession of firearms. The next question, of course, then is, can the government find us some kind of historical analog that says we as a society will accept those sorts of limitations? The problem is is that when we look at the most relevant time period, right around the colonial period of time where we're adopting the Second Amendment, ratifying our Constitution, you see actually there was actually not a restriction on the manufacturing of firearms. It was rather really expected. As the plaintiffs wisely point out, the possession and use of non-firearm objects to self-manufacture is certainly nothing new. In fact, they have been commonly possessed and used by law-abiding citizens for such purposes, including the self-manufacture of arms for self-defense throughout American history. Manufacturing of firearms was not just common, but was entirely unregulated during our colonial and founding eras, and there were no restrictions on who could be a gunsmith or manufacture arms. And, sometimes the devil is in the details. And what the Firearms Policy Coalition very wisely have pointed out here is saying, hey, listen, if you look at the plain language of the statute, there's no requirement that somebody who is making a firearm at home actually attach a serial number to it. That is only required for licensed manufacturers and importers. As they point out, federal law only requires that licensed importers and licensed manufacturers shall identify by means of a serial number engraved or cast on the receiver or frame of the weapon each firearm imported or manufactured by such importer or manufacturer. Now, here's the thing I want everyone to geek out on, because I think this is the most fascinating part of this argument. They're saying that, listen, none of these firearms can be banned because of the common use test. And at first I was like, really? Oh, okay, how are we going to get there? But once I read their argument, it made complete sense. It'll make complete sense to you. In a nutshell, one of the firearms that was in question here is a Glock handgun clone that was built from a polymer 80 lower. Now, let's just assume for the sake of this hypothetical that it's a Glock 19 clone. All right, we will have a fully functional semi-automatic firearm that will look pretty much exactly like a Glock 19 and function pretty much exactly like a Glock 19. When we're determining whether or not these types of firearms are in common use, we're not breaking it down based upon whether or not they're serialized or not. Instead, we need to break it down based upon the type and platform of firearm that we're talking about. So what here we're talking about in one of the firearms in question is how common is a semi-automatic handgun that accepts a detachable magazine? And the answer is, it's the most common firearm found anywhere in the United States. And it's not the serialization that matters. Consider this. We know that we cannot ban firearms in the United States unless the firearms are both dangerous and unusual. However, when we go to define what makes a firearm unusual, we are not going to mention the fact that it does or does not have a serial number. That's not what makes the firearm unusual. That's not how we're defining that term. Instead, we're going to define by what platform of firearm is it, what does the firearm actually do, what is the lethality of the firearm, what is the firing rate, and things like that. So a Glock 19 clone built from a polymer 80 lower, shockingly, will function almost in exactly the same way as a regular Glock 19. It is clear that the Second Amendment protects possession and use of weapons that are in common use at the time. Given that the firearms that the plaintiffs desire to manufacture are merely semi-automatic handguns, which Heller recognized are the most popular firearms in the nation, the government could not possibly show Delaware's law functions to prohibit firearms that are dangerous and unusual. And so ultimately, if we're talking about the types of firearms, and we're not breaking it down by serialized or unserialized, we're breaking it down by semi-automatic handgun, which accepts a detachable magazine, the plaintiffs, Firearms Policy Coalition here, correctly points out, thus, so long as the firearms subject to the ban are arms in common use for lawful purposes, they are protected by the Second Amendment's unqualified command. Now, in addition to that really good argument, remember I mentioned that when this law went into effect, it said, listen, you cannot possess one of these firearms. There was no grandfathering clause at all, which means thousands of Delaware residents became criminals overnight. Now, since they obviously had to either turn their firearms in or destroy them, they were given just compensation by the Delaware state government, correct? No. They've never received a single penny, which means that this is an unconstitutional taking, which is in violation of the Fifth Amendment and also in violation of the 14th Amendment as applied to the state of Delaware through that amendment. And as this court has already astutely observed, what matters is that sections 1459AB and 1463A criminalize the possession of unserialized firearm frames and untraceable firearms without providing any way for plaintiffs to keep firearms they lawfully manufactured. In other words, Delaware is criminalizing the possession of once lawfully possessed firearms without giving plaintiffs any opportunity to maintain possession of their firearms by applying for a serial number. And then finally, this ban, which basically says, hey, listen, you cannot possess, you cannot disseminate, you cannot receive any sort of schematics, diagrams, blueprints, anything necessary to 3D print firearm components, is clearly a violation of a person's First Amendment right. Now, there is already case law that says computer code will constitute speech, and so therefore it can be protected by the First Amendment, as FPC wisely points out. Additionally, upholding the instruction ban while enjoining the remaining bans would create a peculiar and untenable result, where the activity of self-manufacturing firearms and possession of the resulting products are recognized as constitutionally protected, but the distribution of computer source code simply to facilitate the exercise of this constitutionally protected activity to produce this constitutionally protected property is not. And as they point out, the ban would criminalize this speech regardless of whether or not it's connected at all with any sort of criminal activity. So listen, the case once again is Rigby v. Jennings. We'll link it up down below so that you can geek out on it for yourself. I really like where the Firearms Policy Coalition is going here. I love the application of the common use test, and there is a lot of very loaded issues contained in this very concise memorandum. If you guys got any other questions about this or anything else related to what's left of our Second Amendment rights, you should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information's down there in the description box as well. And then finally, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.